There is a stark understanding while we define section 2D to be what constitutes design. The one aspect which is involved is that artistic nature which is protected by copyright law cannot be protected under design law. So there may be certain designs which can anyway qualify for registration both under the Design Act and Copyright Act. And this industrial design or product design are covered by Designs Act of 2000. Therefore, if an original artistic work has been registered as a design under the Design Act, then the same subject matter cannot enjoy a coterminous protection under the Copyright Act. However, if a design qualifies for registration under the Designs Act but has not been so registered, then the exclusive right will subsist under the Copyright Act. And if such a design is of an article which is commercially produced, the copyright over the design under the Copyright Act will cease to exist when the article to which the design has been applied has been reproduced more than 50 times by an industrial process by the owner of the copyright. So this is a good way of establishing distinct protection for the same subject matter which may seem to overlap between two species of intellectual property law, namely design and copyright. When you read the requirements for design law or as design law clarified along with section 15(2) of the Copyright Act, we understand this distinction far more. The legislature's intent to allow a person who actually contributes with an aesthetic design as opposed to an artistic work under copyright law can be understood by comparing the kind of works and the impact or the effects or implications of protection extended to both species. So here is a table in this slide which explains this distinction. There are exclusive rights, that is, complete monopoly for large-scale production, when most countries also confer exclusive rights under design law, whereas in copyright law, it only protects against copying. Design needs to be registered. However, like I mentioned, copyright law is accorded automatically. Thus, there are no formalities of registration process which are mandatory. Design law requires originality and novelty, while copyright law's criteria for protection is originality alone, which means originating from the author, which is easier to fulfill as compared to the novelty bar of the design law. The duration of protection is 10 plus 5 years and can be extended further due to renewal. So a total of 15 years is a maximum term of protection for a design law. However, the duration of protection in case of copyright is much longer, which is life of the author plus 60 more years. And finally, a design can only be confined to the product that it has been registered upon. However, copyright law is not product specific. So the class of goods for which a particular design has been applied to is what protects and limits the scope of protection in design law, as opposed to what is protected in copyright law, which is not product specific. Let's understand what leads to actually infringement of a design right. And this is termed as design piracy, as mentioned in section 22 of the Act. Design piracy would mean an activity to publish or to have it published or expose for sale any article of the class in question on which either the design or any fraudulent or obvious imitation has been applied. To either apply or cause to apply the design that is registered to any class of goods covered by registration, the design or any imitation of it, and finally to import for the purpose of sale any article belonging to the class in which the design has been registered and to which the design or fraudulent or obvious imitation thereof has been applied. So in short, design piracy means an unauthorized copying of an aesthetic, appealing attribute of an article for commercial purposes. Section 22, Clause 2 stipulates a remedy against design piracy, and the remedy is a suit for damages, injunction, or for rendition of accounts, which is maintainable only when filed before an appropriate court, which may be a district court or a high court, depending upon the quantum of damages being claimed. What could be the defenses against a design piracy claim? Defenses to a suit of infringement would include functional requirements, as well as the article having no eye appeal. In order for infringement to be found, the court must determine whether the alleged infringing designed article has the same shape or pattern and eliminate any claims for similarity. The remedies for a design infringement would include the remedies which are civil in nature, which is an injunction, a suit for damages, delivering up of infringing articles, and criminal remedies would entail imprisonment or fine or even both. As mentioned, the Section 22 Clause 2 stipulates the remedy in the form of payment of money by the person who infringes a registered design. Further, in addition to payment of money, a suit for injunction restraining the infringement of registered design and for rendition of accounts, maintainable only when filed before an appropriate court, requires a sort of a strong remedy available for any person who indulges in creating original design works in India. To understand the overlap between copyright protection and design law, let's revisit the case of Escorts Construction Equipment Limited versus Action Construction Equipment Limited, 1999, PTC 36, Delhi. The Delhi High Court in this matter had the occasion to interpret this part of the definition as contained in the Designs Act of 1911. This case was concerning the alleged illegal copying of a design by the respondent of pick and carry hydraulic self-mobile cranes manufactured by the plaintiff. Though the case was not directly coming under the Designs Act, the court examined whether the said design was capable of registration under the Designs Act. And after examining the definition of the design under the Act, the court held that the design in question was incapable of registration. According to the court, the definition made it amply clear that the primary objective of the Act was to protect shape and not function or functional shape. And the expression design does not include a method or principle of construction of features or shape or configuration which are dictated solely by the function which the article to be made in that shape or configuration has to perform. So, rejecting the contention of the plaintiff, who claimed protection of certain specific parts of the crane, the court held the aforesaid parts of the crane are made in a particular shape so as to interrelate with others mechanically. And these parts of the crane are not made to appeal to the eye, but solely to make the crane work or function better. So, most of the key components or parts unseen in the crane for which they were required had only to pass the test of being able to perform their function, and they would be judged by performance and not by appearance. Consequently, the aforesaid key components or parts are incapable of being registered as designs, and therein we understand what can be an artistic work, but if found to be overlapping or having any functional attributes which are more than just mere appealing to the consumer's eye, they will be excluded from the protection of design law. So that is what this entire module contains. Let's revisit the learning points. We began by understanding the legislative history of design law, and the present Act of 2000 and the rules of 2001 apply is what we learned. Thereon we understood the definition under section 2D and fragmented the definition to understand the meanings of what means or what is the essence of design protection. The two attributes which contain or as prerequisites for design protection are visual aspects, and this visual aspect needs to be necessarily applied to an article. And finally, we went on to separately study about the overlaps with design protection and protecting it from any functional design protection which is then falling into the subject matter of patent law and away from design law. We've also understood that landscaping, architectural works, buildings do not constitute design protection. So industrial design, though requires industrial manufacture, all it essentially is trying to protect is an aesthetic value or an ornamentation to an applied article. And therein we've learned that industrial design leads to rewarding a creative individual who ends up adding beauty to an article and therefore adding value to its commercial value to such article by appealing to the eye of a prospective consumer. I hope you enjoyed learning this and keep your thinking caps on. Thank you very much.